Welcome back. Hope you are having a great day. And in the last mini lecture, I concluded the political culture discussion. And today I want to start a brand new kind of topic, the Constitution and Federalism. And if it's true that federalism is the constitutional division of power between the national government and the states, which it is, we need to begin our discussion by looking at, well, what powers belong to each of the actors. In other words, which powers belong to the national government, which powers belong to the states, which powers may belong to both of them, and actually there are a lot of powers that belong to both actors. And at some point, as we talk about this, we may talk about perhaps there are some things that actually neither one of them can do. So if you scroll down to powers of government, I'm going to give you the definitions of four words. You should know all four of these for exam purposes. And I'm not going to give you a textbook definition. I'm going to use these words in the manner in which I'm using them throughout not only the section on federalism, but also later in the course. So I want you to put some stars next to enumerated. And when I use the word enumerated, I am merely referring to the powers of the national government that are specifically listed or granted by the Constitution. So, in other words, when I'm talking about enumerated powers of the national government, that means you could grab the Constitution, you could open it up, you could get a yellow highlighter, a yellow pen, and you could begin underlying various powers. And I'll just give you a couple places to look where there are a whole bunch of them listed. If you were to open up your Constitution to Article 1, and Article 1 deals with the Congress, Section 8, you would find 17 of them that are very specific in many cases, like coining money, declaring war, regulating interstate commerce, establishing post roads and offices, patents and copyrights, weights and measures, etc. Those are enumerated. Those are specifically listed. Those are specifically granted in the Constitution to the Congress. The Constitution also grants some powers to the president, such as the president can veto bills that are proposed by the Congress. The president is the commander-in-chief of the military. The president has the power to nominate Supreme Court justices, etc. So enumerated powers aren't very sexy. The power is very specifically laid out. For example, Governor Newsom here in California cannot declare war. That's something that the Congress does, right? Governor Newsom doesn't have the power to nominate a U.S. Supreme Court justice. That's a power that belongs to the president. So the power is specifically laid out in the Constitution. Congress has certain powers. The president has certain powers. And, of course, the Supreme Court has certain powers. So enumerated powers, there's no real dispute here. The Constitution lays out the turf or power in a very, very specific way. The second power of government, or powers of government, really aren't controversial at all either. Concurrent powers. Concurrent powers are powers that belong to both the national government and the states. Examples would include court systems, taxation, etc. So in the state of California, we have a court system. At the bottom of the court system, there are 58 superior courts. There is a superior court in every county in California. Above the 58 superior courts are 6 California Court of Appeals. And then there is a California Supreme Court, with 7 justices on that court. So that's the California state court system. The U.S. court system has 94 district courts, 13 courts of appeal, and 1 Supreme Court with 9 Supreme Court justices. So there is a California court system. There is a federal court system. Depending on whether an individual commits a state or a federal crime, that individual would either go through the state court system or through the federal court system. Obviously, both the state of California and the national government, they both have a prison system. There are federal prisons and there are state prisons. There is a federal income tax, and the state of California also has an income tax. Some states do not have a state income tax, but most states do. Both the national government and the states can borrow money, for example. Obviously, both of them pass laws. There are a lot of concurrent powers. And needless to say that if both the national government and the states both have the power to do something, there really isn't anything to fight over at all. The third power of government that is mentioned in your notes are reserved powers. And reserve powers are powers that belong to the states. And a big one, a really important reserve power that the states have, is something that I talked about at length when I was talking about the Constitution. The Constitution can only be changed if 3/4 of the states agree. Because while Congress can propose a constitutional amendment, only the states can ratify an amendment. So if the states do not agree to a change in the Constitution cannot be changed at all. States also conduct elections, and some say that perhaps this should be changed in the Constitution. There has been calls to have one national standard for how elections are conducted, because the argument is that some states really don't safeguard their electoral process very much. But as of right now, it is states that conduct elections, and that is their power, and the national government has only very, very limited oversight over elections. States, perhaps most importantly, create intra-state boundaries. So I mentioned earlier that the state of California is divided into 58 counties. I told you that there has not been the creation of a new county in the state of California since 1908. There has been a lot of scholarship. There have been lots of calls for California to rethink the county boundaries that exist, that the county boundaries of 1908 are no longer appropriate for the California of 2020. And I'll just give you my 2 cents worth. There probably should be more than 58 counties in California. Many people have claimed that if the counties were more uniform in size and there were more of them, county services might be more responsive. An example of this, and critics criticize Texas for the opposite. A lot of experts criticize California for only having 58 counties, but I've also read articles critical that the state of Texas, the state that is nearest in size to the state of California, that the state of Texas has 254. Whether California has too little, whether Texas has too much, the point is that the state of Texas and the state of California have taken very, very different approaches to local government, and whether one is better or not is left to a discussion probably in a graduate seminar and goes way, way, way beyond my knowledge level. But certainly it is interesting to me that there is such diversity, right? We talked about how federalism permits diversity. So here's another example. Two states that are almost the same size, Texas with 254 counties, California with only 58. Whether one is better or not is left for another day. The last one, and the one that I want you to ponder the most, to put the most stars next to, are implied powers. And the way that I think about implied powers is, are there jokers or wild cards in the Constitution? If any of you have ever played poker, and when I was an undergraduate student, I played poker for money, kind of semi-professionally. I was a mediocre player. I won't brag too much because I actually played against a real good player one time. In fact, it was a man who probably has made over $10 million. I'm sure he's long dead now, but at the time I played him one-on-one, he'd made over $10 million playing poker, and I played him for 2 hours and I lost $1,200 in 2 hours. So he was either really good, I was really bad, or a combination of the two. But I did make money. I made enough money to get by. So implied powers, this is really where I believe the debate over federalism begins. And essentially the question is this. We know the national government has vast implied powers. No debate about that. Congress can coin money, can declare war, can regulate interstate commerce. The president is commander-in-chief of the most awesome military in the world. The president does nominate Supreme Court justices. There's no debate about any of those. That is true. But the debate is, does the national government only have enumerated powers, the powers that are granted in the Constitution, or do they have powers that extend beyond the literal language of the Constitution? And certainly history has determined that the national government does indeed have vast implied powers. But from a purely constitutional perspective, should this be the case? So I want you to consider one that's in your notes. If you turn to Article 2 of the Constitution, Article 2 deals with the presidency. It starts with, quote, the executive power shall be vested in a president of the United States of America. And what does that mean? Do the words executive power just confer a title on the president? Just means he's the president? Or does it bestow a broad swath of implied power? And presidents themselves have disagreed, and they have disagreed tremendously. I'm going to talk about the next provision a lot more in the last section of the course, and I will test you on that later on in the course. But for now, I just want you to think about the concept. I'm not going to test you on this. So literalists are presidents like William Howard Taft, James Buchanan, Warren G. Harding, Calvin Coolidge. These presidents believed that the president had enumerated powers only, and there were no implied powers. It just meant I'm the president and I have the power and prestige associated with it. But their notion was those words, executive power, it's just a title. Presidents like Teddy Roosevelt, Abraham Lincoln, Richard Nixon, and no question Donald Trump believe that unless the Constitution specifically prohibits that particular power, he has the power to do it. Now, just knowing those two perspectives on presidential power, you're going to have very, very different presidents. For example, Richard Nixon once in an interview with David Frost said, if the president does it, that means it's not illegal. I don't think there is anything in the Constitution that suggests the president is that far above the law, but certainly Mr. Nixon and Mr. Trump has publicly reiterated that essentially as president, there are virtually no restraints on his power. And so he is taking an extreme view of stewardship, just like Richard Nixon did. In the next mini lecture, we will talk about the nation-centered view of federalism.